Good morning to everyone present here. I, Bhakti Chandan, on behalf of the Mood Court Society, take immense pleasure to welcome you all to the final round of the second PGCL SARC International Mood Court Competition 2022. I, along with Atharva Lama, will be the courtroom officers for today's proceeding. It is my honor to introduce the esteemed bench of judges for today's rounds. We have Additional Solicitor General Shashi Prakash Singh, serves an additional Solicitor General at the Allahabad High Court. He is also a senior advocate of the Lucknow bench of the Allahabad High Court. He was appointed as the new Advocate General of Uttar Pradesh and also served as a National Vice President of the RSS Advocacy Council. We have Additional Solicitor General Vikramjit Banerjee, who is a senior advocate from the Guwahati High Court and is also the Additional Solicitor General of India and the youngest of the three Additional Solicitor Generals appointed at the Supreme Court of India. Lastly, we have Senior Advocate Pradeep Rai, who is also the Vice President of the Supreme Court Bar Association. So has over 2 decades of standing at the bar in the Supreme Court of India, various high courts, commissions, regulatory bodies, and tribunals. He has worked closely with former Chief Justices M.N. Venkatachalya and Justice J.S. Vanwa to strengthen human rights conditions across India. On behalf of SVKM's Praveen Gandhi College of Law and the Mood Court Society, I extend my gratitude to all the judges for gracing us with their presence. Without further ado, I will briefly state the rules and the speaker time in order. From the prosecution, we have T522. Prosecution Speaker 1 will take 18 minutes. Prosecution Speaker 2 will take 20 minutes. That leaves them with 2 minutes for rebuttal. T510 will be the defendants. Defendant Speaker 1 will take 19 minutes. Defendant Speaker 2 will take 18 minutes. That leaves them with 3 minutes for rebuttal. Coming to the rules, I request the participants to keep their cameras on at all times. Switching off of the same will lead to disqualification. Each team shall be allotted a total of 40 minutes to present their oral submissions. Each speaker must speak for a minimum of 17 minutes and a maximum of 20 minutes. There shall be a warning given by the courtroom officer 2 minutes prior to the allotted time and once again at the end of the allotted time. So please be mindful of the same. Teams will have to allot time for the rebuttal and sur-rebuttal respectively. The teams may reserve a maximum of 3 minutes for rebuttal and sur-rebuttal. Rebuttal and sur-rebuttal will, however, be at the discretion of the judges. Any extension of time will be at the discretion of the bench. There shall be no cross-talking during the proceedings. The judges can ask questions anytime they want. Only the designated teammate will be speaking at a time and the rest will be on mute if there's any disturbance in the background. The opposite stays on mute throughout as the current team speaks. Screen sharing of the compendium or any document shall be done with the prior permission of the bench. Please maintain the decorum of the courtroom throughout the competition. If in case one speaker loses connection, the courtroom officer shall request the bench to stop the proceedings for 2 minutes. If connection is re-established, then the same speaker continues or else his or her co-speakers takes over and concludes the submissions. The structure of the competition shall be as follows. Prosecution Speaker 1 shall make all their submissions, followed by Prosecution Speaker 2, then Defendant Speaker 1 and Speaker 2. The rebuttal and sur-rebuttal will be at the discretion of the judges. Any changes with respect to the structure should be intimated to the bench prior to the commencement of the rounds. The participants, however, are free to combine any of the issues as long as the per speaker time is not exceeded.
Court officers, can we begin?
Just give us a minute. Just a minute.
Sure.
Senior advocate Chinmoy Sharma is also a part of the bench. I sincerely apologize to you, sir. Mr. Chinmoy Pradeep Sharma is a senior advocate practicing in the Supreme Court of India. He has appeared in landmark cases ranging from constitutional law issues to criminal cases. Sir has a vast experience of conducting complex domestic and international commercial. Sir is also a founder of Nyaya Darshan, a platform which provides free legal advice and litigation and mediation services. So I sincerely apologize for the mistake at our end.
We may begin with the proceedings if the lordships are okay with it. Participants, you all can begin. Thank you. All the best to everyone.
Permission to approach the bench. Permission to address the bench collectively as Your Excellencies. Your Excellencies, Team Code 522 shall be representing the side of prosecution in the case of Prosecutor versus Tidmus Wolf of Jana Clan. Agent 1 shall be taking 18 minutes of this court's time to deal with the first issue, and my co-agent shall be taking 20 minutes of this court's time to deal with issues 2 and 3. Your Excellencies, the agent also seeks permission to share the screen in order to present the compendium wherever necessary, Your Excellencies. Your Excellencies, prior to the presentation of arguments, the agent shall be stating the brief facts. The facts state that Jana clan is a democratic, non-secular country with 27% people professing the Vedic religion. A famine was experienced in the Nanji region, and newspapers reported that a substantial impact was caused on the Vedic community, Excellencies. Mr. Wolf, being the Prime Minister, acted with a discriminatory intent against the Vijans. Subsequently, a quasi-judicial investigation was instituted. Moving ahead with the presentation of arguments of issue 1, that is whether the International Criminal Court has jurisdiction under Article 17 over the situation of intentional famine in the state of Jana clan. Your Excellencies, this aspect shall be argued in a twofold manner. One, which deals with the aspect of jurisdiction of the International Criminal Court under part 2 of the Rome Statute, and the second aspect shall be dealing about with regard to admissibility, specifically under Article 17, Your Excellencies. Addressing the first aspect of jurisdiction, Your Excellencies, that is part 2 of the Rome Statute, it is argued that the statute was in force in the state of Jana land since 2007. Thereby, taking cognizance of a case that occurred in 2020 fulfills the requirement mentioned under Article 11 of the Rome Statute. Subsequently, Your Excellencies, it is noted that the preliminary investigation by the Office of the Prosecutor was with the approval of this pre-trial chamber, and it was conducted in accordance with Article 13 Clause C and Article 15 of the Rome Statute. Additionally, the crime in question is that of genocide and crimes against humanity, which is well within the subject matter jurisdiction of this court under Article 5. Moreover, Your Excellencies, it is possible for us to try Mr. Wolf under the exercise of jurisdiction under Article 12, Clause 2, Subclause B, as Mr. Wolf is a national of a state that is party to the statute. Thereby, this fulfills all the necessary elements in order for the ICC to exercise your jurisdiction. Moving ahead to the next limb of the argument, that is with regard to admissibility, Excellencies. Your Excellencies, it is essential to note that the acceptance of jurisdiction is a precondition to the case of admissibility. And now that jurisdiction is established, we shall be dealing with the admissibility aspect. In order to prove this, the provisions of Article 17 of the Rome Statute should be fulfilled. Uh, the verbatim of Rome Statute is being presented by my researcher, Your Excellencies. It is pertinent to note that the chapeau of Article 17, Clause 1 adopts a negative connotation of the word admissibility. Thereby, for a case to be admissible, none of the elements mentioned in Article 17, Clause 1 must be fulfilled. And the same shall be hereinafter explained, Your Excellencies. The basic principles that is highlighted in Article 17 is that of complementarity, double jeopardy, and gravity threshold. Your Excellencies, Article 7, Clause 1, Subclause A says that if the case is being investigated or prosecuted by a state, thereby this particular subclause shall not be applicable, because in the instant case, the matter has already been investigated and it is not in the process. Thereby, the applicable clause shall be that of B. That shall be subsection B. In subsection B, I request my researcher to scroll. Yeah, thank you. In subsection B, it is stated that the case has been investigated by a state which has jurisdiction over it, and the state has decided not to prosecute the person concerned. Thereby, and it is followed that unless the decision resulted from the unwillingness or inability of the state to genuinely prosecute. Your Excellencies, it is pertinent to note that this particular clause provides for the complementarity principle, and the prosecution respects this complementarity principle, where we state that the ICC does not have primary jurisdiction over national authorities but merely complements it. Under subsection B, Your Excellencies, they stated, you've used the word investigated or prosecution, Your Excellencies. What requires deliberation is the nature of investigation conducted by Janakland, Your Excellencies, in the first instance. The first aspect that has to be noted is that the state of Janakland has conducted a quasi-judicial investigation into the matter. It is pertinent to note that Article 1 of the Rome Statute states that the International Criminal Court is complementary to the national criminal jurisdiction in Article 1, Your Excellencies. The highlighting word here is that of criminal jurisdiction. Thereby, the most important aspect to note is that the investigation that has to be conducted should be that of a criminal nature and not something that is non-criminal in nature, since the threshold of proving a criminal case is higher than the threshold that is required in any other cases, Your Excellencies. It is also pertinent to note that the manner and functioning of quasi-judicial bodies is usually different from the functioning of a criminal case, Your Excellencies. Your Excellencies, it is also pertinent to note that the aspect of having exercising criminal jurisdiction is highlighted in the case of Prosecutor versus Katanga, where it was affirmed that states have a duty to exercise their criminal jurisdiction over international crimes, explicitly referring to criminal proceedings, Your Excellencies. Moving ahead, Your Excellencies.
Counsel, I just want to ask you a question. Article 17 is apparently very clear. It does not very specifically say, if I read it correctly, that there has to be a criminal prosecution. Now, what you are trying to do is to, and you know, when you sort of attach criminal liability, it has to be strict. You can't imply criminality by implication from other portions of the statute. Now, don't you think that what you're trying to do is basically override the jurisdiction of the national courts rather than which you have as a complementary jurisdiction?
Indeed not, Your Excellencies. It is pertinent to note that the entire statute must be taken, the objective and purpose of the entire statute must be taken into consideration, Your Excellencies, and each element should not be looked at in an isolated manner. And this was also being, this is a rule that is established under Article 31 of the VCLT, which speaks about the interpretation of statutes, where while examining each element, the entire object's essence has to be taken into object.
Corollary to that is, an obvious corollary to that is, and that is what the next question is, which is the crux of it, is do you have a judgment or a citation or whatever, any example whereby this court has exercised jurisdiction even when the states have sort of come to this conclusion or are in or a quasi-judicial, even a quasi-judicial sort of examination of the events?
Indeed, Your Excellencies, in the case of prosecutor versus Katanga itself, it was observed that only reports, like only NGO reports and NGO investigations were considered by the authorities, and there was no usage of witnesses, examination of evidences, and all these aspects. Thereby, the International Criminal Court stated that the national jurisdiction cannot be, the exception of complementarity cannot be taken into consideration, and the same was tried before the International Criminal Court, Your Excellencies.
But you don't have a sort of a knowledge of what is the procedure being followed here. Here, there may be a quasi-judicial procedure, so there can be witnesses and things, and that's all. That's just the question.
Your Excellencies, but the threshold of having a criminal jurisdiction is not met, Your Excellencies. It is also pertinent to note that quasi-judicial bodies are generally bodies that usually are like they're established to interpret a limited law or based on a particular subject matter, Your Excellencies. If we look at it, generally the quasi-judicial bodies that are existing in several parts of the world. Like for example, in the United States, we have the Federal Trade Commission and the Federal Aviation Commission. In India, we have the Competition Commission, the RBI, SEBI, and all these kind of quasi-judicial bodies. These are limited to one particular subject matter, and they're merely implementing the law that's already been created, and they're not examining aspects at a higher threshold, Your Excellencies, and that is the point that Agency is trying to establish. Indeed, Your Excellencies. Your Excellencies.
While on that, I'm sorry, while on the interjection, you drew the attention of the bench to Article 17.2. Now, how do you demonstrate that the requirements under 17.2 have not been met?
Indeed, Your Excellencies, I should be demonstrating the same. Your Excellencies, if we read, I request my researcher to share the Rome Statute. Article 17.2, the chapeau of Article 17.2 clearly states the aspect of due process must be followed. I request just 1 second of the, yes, Your Excellencies, it's displayed here. It says, in order to determine unwillingness, the court should consider the principle of due process recognized by international law, Your Excellencies. The agent is trying to, the agent argues that this decision taken by the quasi-judicial body is with a breach of due process that exhibits that a state is unwilling or unable to prosecute, Your Excellencies. The aspect of due process should include justice from the standpoint of procedural and perhaps even substantive fairness, including rights of the victim to have a perpetrator punished in relation to a criminal proceeding, Your Excellencies. Your Excellencies, it is also pertinent to note that the European Commission on Human Rights has stated that the notion of an effective remedy the aspect of effective remedy is enshrined in Article 13 of the ACHR, and it also entails, in addition to the payment of compensation, where appropriate, this was held in the case of Kaya versus Turkey, Your Excellencies. It was stated, in addition to the payment of compensation where appropriate, a thorough and effective investigation capable of leading to the identification and punishment of those responsible, and including effective access to the relators of the investigatory proceedings. And it was also held that the conduct must be conducted in such a manner to have the victim should have the right to have the perpetrator punished, Your Excellencies. Thereby, Your Excellencies, in the instant case, by following a lower threshold, there is no fair trial that is being given. There is no, the fairness clause is not being given, which is the right of the victim, is not being given to them, Your Excellencies. Thereby, by violating the chapeau of Article 17 Clause 2 itself, It is stated that this particular case is admissible before the Honorable Court, Your Excellencies. Moving ahead to the next aspect, Your Excellencies, that is Article 17(1) Clause C. Your Excellencies, Clause C speaks about a trial that has already been taken place, and this subclause shall not be applicable, since in the case of Janakland, there was no trial that was initiated in itself. Thereby, the next section, the next subclause that has to be considered is that of Article D, subclause D. Your Excellencies, in order to prove the gravity threshold, it's a requirement that has to be met above and beyond the jurisdictional mandates. Thereby, in the pre-trial chambers, in the case of Democratic Republic of Congo situation, has established two main aspects, Your Excellencies. The first thing is that the relevant conduct must be systematic and widespread. Your Excellencies, it is submitted that in the instant case, the discriminatory policies adopted by Mr. Wolf directed against a particular part of the population with an intention and knowledge to cause destruction is sufficient to establish systematic and widespread nature, Your Excellencies. Your Excellencies, it is also submitted that this aspect shall be dealt in detail by my co-agent, since this is the third issue, Your Excellencies. Your Excellencies, it is also pertinent. The second aspect says that the condition should have created a social alarm, Your Excellencies. So the social alarm should be caused in the international community as a whole. In order to establish the creation of a social alarm, Your Excellencies, what has to be considered is that in the instant case, the crimes committed in the state of Janakland is that of genocide and crimes against humanity. The crime of genocide is creates an erga omnes obligation on the entire international community, and the international community usually takes measures to prevent genocide. Thereby, the states by themselves also have the authority to initiate charges against states when aspects of genocide are committed, Your Excellencies. Thereby, the very existence of genocide in itself shows that there's an international, there's a social alarm caused in the international community. Furthermore, it is also stated that because of the intensity and destruction of substantial amount of the population, the Office of the Prosecutor has started its investigation with the approval of this Honorable Pre-Trial Chambers, Your Excellencies. Furthermore, Your Excellencies, the last aspect that is required is that the most senior leader shall be the most responsible. This has been established in the case of Prosecutor versus Dailo, where it can be seen that the person who was convicted here was the president of UPC, which was a group that was involved in committing the crimes against humanity. And this individual person who was prosecuted was also the commander-in-chief of that particular community, Your Excellencies. And the International Criminal Court stated that this person, that is Lubanga Dailo, shall be responsible as he is the senior most person, being the most responsible for the commission of this crime, and thereby they convicted him, Your Excellencies. Similarly, Your Excellencies, applying this ratio in the present case, Mr. Wolf, being the Prime Minister of the country, and also the person who has directed the senior most government officials to act in a discriminatory manner against the region population, is sufficient to state that Mr. Wolf is the most senior and the most responsible for the crimes committed. Thereby, it is well within the jurisdiction of this court, and it is well within the admissibility clause to try Mr. Wolf in the instant case, Your Excellencies. Your Excellencies, if you're satisfied with the presentation of the arguments under admissibility aspect, my co-counsel shall deal with the subsequent issues. Indeed, Your Excellencies, it was a pleasure arguing before this court.
Yeah. Permission to approach the bench.
Much obliged, Your Excellencies. Your Excellencies, agent number 2 will be dealing with issues 2 and 3. Issue 2 pertains with whether Mr. Wolf has specific intent as required by Article 6 of the Rome Statute. Through the course of his actions, intent, and policy decisions, the acts of Mr. Wolf constitute a crime of genocide under Article 60 of the Rome Statute. Your Excellencies, genocide amounts to those acts seeking physical or biological destruction of all or a part of the group, Your Excellencies. Article 6 states that for a crime of genocide to be committed, intent to either destroy wholly or in part a religious, ethnic, racial, or a national group must exist. Your Excellencies, the physical act of the perpetrator, coupled with the aspect of mens rea, which includes the knowledge and intent, categorizes a crime as a crime of genocide, Your Excellencies. Your Excellencies, the Article 6 of the Rome Statute has been derived from Article 2 of the Genocide Convention by the Genocide Convention, Your Excellencies. Your Excellencies, in the instant case, Mr. Wolf's actions of deliberately inflicting dire conditions of life on the Vajans in the Nanji region were a religiously distinct group who were the object of the attack by causing an intentional famine and deprivation of food and essential resources, which led to the subsequent destruction, fulfills the actus reus element in the instant case, Your Excellencies. The genocidal intent, as described in the case of prosecutor versus Jelicic, is fulfilled by the actions of Mr. Wolf deliberately targeting the Vajans, which caused the deterioration and large-scale death of the Vajan community in the Nanji region, Your Excellencies. Furthermore, Your Excellencies,
can I interject? You say that there has been a deliberate attempt. Can you show us from the facts the instances on the basis of which you are saying that, and how do you prove specific intent?
Much obliged, Your Excellencies. Your Excellencies, if I may have the court's kind perusal towards para 21 of the fact matrix, where according to certain WhatsApp chats in the possession of the Office of the Prosecutor, it revealed that Mr. Wolf had directed senior government officers to ensure that there was no food shortage for the Andal people, and to this end, he had instructed them to divert food supply from the Nanji region, specifically from the Vajan population, towards other parts of Jhanakland, Your Excellency.
So, a further question to complement my learned friend. So basically, you are relying on WhatsApp chats for the purpose of invoking jurisdiction of this court. What is the admissibility of WhatsApp chats or evidence like this for the purposes of
much obliged, Your
admissibility of this
Excellencies.
court? Do you have any authorities to cite on that?
Yes, Your Excellencies. Your Excellencies, as Article 69, Clause 4 of the Rome Statute further outlines that the court may rule on the relevance or the admissibility of any evidence, taking into account the inter alia, the probative value of the evidence, and any prejudice that such evidence may cause, Your Excellencies. Your Excellencies, if I may bring the court's kind perusal to the case of prosecutor versus Jean-Pierre Bemba, it was held that the prosecution sought to introduce into evidence 10 audio recordings and broadcast that provided background information, Your Excellencies, but the defense questioned the authenticity of such digital evidence. The judges, however, ruled that recordings have not been authenticated in the court can still be admitted, as in-court authentication is but one factor for the chamber to consider that when determining an item's authenticity and probative value. Your Excellencies, the court having the discretion to decide on the admissibility must consider the probative value and the nexus that the digital evidence that is produced before this honorable court, Your Excellencies. Since WhatsApp transcripts have the timestamp and the date that are procured as the transcripts with the transcripts that are procured by the Office of Prosecutor, the time and the date can also be verified, Your Excellencies. And furthermore, there are various other instant cases where the chambers of the ICC where the chambers of the ICC by its discretion has accepted digital evidence in a corroborative sense with the other such evidences that have been produced before this honorable court, Your Excellencies.
Here, the evidence is not corroborative. Here, the evidence is primary. You're convicting a head of state based on WhatsApp chats.
Much obliged, Your Excellency. Your Excellency, it is pertinent to note that the prosecution is not convicting merely based on the WhatsApp chat, Your Excellencies, but the series of acts and the series of reactions and the consequences that the acts of Mr. Wolf has caused in this instant case and in the state of Jharkhand, Your Excellencies. No doubt, Your Excellencies, that WhatsApp chats are considered as secondary evidence, secondary form of evidence, and the primary form of evidence is to be considered in the instant case. In the instant case, Your Excellencies, it is pertinent to note that the Nanji region in the state of Jharkhand was the worst affected region and saw innumerous deaths, specifically in the Vajan population, Your Excellency. And this is pertinent to note to prove the intent aspect of Mr. Wolf, Your Excellency. Your Excellencies, furthermore, as my co-agent rightly stated, that being the head of the state, he had a certain responsibility towards protecting all civilians and shielding them from any widespread or systematic attack which he may be involved in, or any other attack that they may be subjected to, Your Excellency. But in the instant case, Your Excellency, Mr. Wolf has deliberately failed to act in order to protect the Vajan population in the Nanji region while being discriminatory, Your Excellency. As the head of the state, he had a legal obligation and he had the knowledge of the dire conditions in the Nanji region, Your Excellencies, which he clearly failed to address and which he clearly failed to act due to his inadequacy, incompetency, and the delay in taking necessary action to control the famine that is caused. Your Excellencies, it is also pertinent to note that he's a staunch Andalian and he came into power knowing well the situation in Jharkhand, Your Excellencies. At the head of the state, it was necessary on him to take necessary action towards the worst affected regions in this instant case, Your Excellencies.
Don't you think that the only corroboration that you have for that is media reports and nothing else?
Your Excellencies, media reports being an open source of evidence, Your Excellencies, which is coupled with the actus reus element of Mr. Wolf in this instant case. And furthermore, Your Excellencies, if I may point out to para 13 of the factual matrix, Your Excellencies, Mr. Wolf himself has agreed that yes, it is true that the shortage of food and potable water in certain parts of Nanji are suboptimal levels, Your Excellencies. Furthermore, we don't have the exact figures yet, but it is safe to say that the media reports are not exaggerated and represent the accurate figures, Your Excellencies. Being the head of the state and confirming his inadequacy and incapacity, furthermore, furthers the intent that he had to destroy this particular group in this instant case, Your Excellency.
Can inadequacy and inability amount to intent?
Your Excellency's inability and inadequacy, as Your Excellencies, it must be considered at what position Mr. Wolf is in the instant case, Your Excellencies. He's the head of the state and not merely any other civilian who can be held responsible without any legal obligation on his part, Your Excellencies. Being the head of the state, having the intention, having the knowledge, and deliberately acting upon that, not just having the intention or not just merely having the intention would suffice. But however, in the instant case, it shows that he acted upon those intentions and acted upon that knowledge that he had towards destroying the Vajan population in whole or in part in this case, Your Excellencies.
Two questions.
Please proceed.
Is there a have you been able to show a manifest pattern, number one? And is there a specific intent? I don't think there is any evidence of specific intent.
Your Excellencies, it is not necessary in this instant case for the policies to be organized or formal, Your Excellencies. The actions with the knowledge and intent is enough to prove that he was involved in the attack against the population, or in this instant case, even genocide, Your Excellencies.
But in your memorial, you have said that you have fairly admitted that there is no policy. So then how would you defend your prosecution then?
Your Excellencies, although there is no formalized policy, Your Excellencies, that is what the word formalized has to be, although it's not present in the memorial, Your Excellencies, it is pertinent for this bench to note that although there is no formalized policy towards the destructions of the Vajans, Your Excellencies, there is the knowledge and intent coupled with the Dolus specialist, Your Excellencies, which fulfills the elements of crime as to consider the crime as the crime of genocide, Your Excellencies. If Your Excellencies are satisfied, if
Continue.
Much obliged.
Please proceed.
Much obliged, Your Excellencies. Your Excellencies, in this instant case, the general intent is deduced from the deliberate acts of Mr. Wolf targeting the Vijay population in the Nanji region, Your Excellencies. Mr. Wolf possessed the deadly conditions in the Nanji region and failed to act, which resulted in the increasing death rates in this instant case, Your Excellencies. In this, Your Excellencies, 22% of the population, 22% of the Vijay population is a substantial number, Your Excellencies, which further demonstrates general genocidal intent, Your Excellencies. Your Excellencies, the aspect of specific intent is the intent to destroy a group in whole or a part, be it the group belonging to a national, ethnic, religious or racial group with active participation and knowledge that should be established, Your Excellencies. Your Excellencies, specific intent is what distinguishes the crime of genocide from other general crimes, Your Excellencies. Your Excellencies, in the case of Prosecutor versus Clistic, it was held that the intent to eradicate a group within a limited geographical area, such as a region of a country or even a municipality, can be considered as genocide, Your Excellencies. The intent required for genocide is satisfied when the alleged perpetrator intended to destroy at least a substantial group in this instant case. 22%, although is not a majority, should be considered as a substantial number in this instant case, Your Excellency. Your Excellency, the gradual destruction of the substantial number of agents through the actions of Mr. Wolf shows his inherent knowledge and the possible consequences that his acts would lead to, Your Excellencies. Furthermore, Your Excellencies, the WhatsApp chat reveals the preference and execution of Mr. Wolf's plan, Your Excellencies, and also he further failed to distribute resources adequately, causing the deaths in the Vijay population in the Nanji region, Your Excellencies. This act also led to the substantial destruction of the Vijay population as enumerated earlier. And in the case of Prosecutor versus Jelisik, it was held that it is sufficient to conclude specific intent was confined and targeted towards a particular community, Your Excellencies. And in this case, the particular community being the Vijay population, Your Excellencies. Your Excellencies, the Vijayans in the Nanji, Your Excellencies, Mr. Wolf and his government targeted the Vijayans in the Nanji region with the knowledge and intention of causing great suffering, serious injury, mental or bodily harm, or the destruction of the group in part, which amounts to genocide under Article 6C of the Rome Statute, Your Excellencies. If Your Excellencies are satisfied, the agent will be moving on to issue 3, Your Excellencies. Much obliged, Your Excellencies. Your Excellencies, issue 3 deals with Mr. Wolf's actions amounts to systematic and widespread attack against the Vijay population, Your Excellencies. Firstly, Your Excellencies, the nature of the attack was widespread and systematic. Widespread refers to a large-scale nature of attack as well as the number of victims that is to be considered. This must be massive, frequent, and carried out with considerable amount of seriousness directed towards a particular object, which can be a civilian population in this instant case, Your Excellencies, and such was held in the case of Prosecutor versus Bashir. Your Excellencies, it is of utmost importance to note that it may be a series of culminative acts of it may be a culminative effect of a series of inhumane acts or one singular effect of one inhumane act with extraordinary magnitude, Your Excellencies. And this was held in the case of Prosecutor versus Katanga. And furthermore, Your Excellencies, such an act must be guided against an object of the attack, which may be a civilian population, Your Excellencies. And in the case of Prosecutor versus Akayesu, it is held that an attack may not necessarily take place due to an armed conflict for it to be considered as a widespread and systematic attack. Your Excellencies, it is furthermore important to note that both widespread and systematic are disjunctive in nature, Your Excellencies, before I prove how the act also is considered a systematic attack. Your Excellencies, in order for it to be classified as a systematic attack, it must possess an organized, non-accidental and deliberate character, Your Excellencies. And in this case, the attack...
Counsel, does it also have to have a pattern? There has to be a pattern of behavior. That's also
Your
the
Excellencies, much obliged, Your Excellencies.
Show me where's the, or show us where's the pattern.
Your Excellencies,
from the fact, you could just demonstrate from the facts.
Yeah.
Much obliged, Your Excellency. Your Excellency, the incapacity of Mr. Wolf to act within the series from the time he came into power, which is in 2019, to the present time, or until the time that that an investigation was launched into his act, or the deliberate nature of his act, even being 1 year, Your Excellency, shows that there was a pattern although it may not be as evident as it was during the period of famine, where the Nanji region faced dire conditions and where the deliberate acts of Mr. Wolf shows that it was a systematic and widespread attack. It shows that since the time of his tenure in 2019 to the year until he was charged, or even the present conditions as the facts are silent in this instant case, it shows a pattern, Your Excellencies. And furthermore, as I've already pointed out, Your Excellencies, it may be a culminative effect of a series of inhumane acts or a singular effect of one inhumane act with extraordinary magnitude, Your Excellencies. And such was held in the case of Prosecutor versus Katanga, Your Excellencies. Your Excellencies, the chambers have taken a wide interpretation of what constitutes a systematic and widespread attack, Your Excellencies. And although it may not be systematic and it may not be repetitive, Your Excellencies, if one inhumane act constitutes a large magnitude of savagery, it can be considered as a widespread attack, Your Excellency. Furthermore, Your Excellencies, in order for it to classify as a systematic attack, it must be organized and non-incidental and must be deliberate in character, Your Excellencies. The attack carried out through the actions of Mr.
Then how do you explain at para 14 of the problem the press conference statement which is given by Prime Minister Wolf?
Your Excellencies, although he promised to place an embargo on all export and buy food grains domestically with the intent of distribution, he, however, left out the wages in the Nanji region from gaining equal benefit from this embargo that is placed, and from the policy of Mr. Wolf trying to buy out the resources and distributing it equally as he intended, Your Excellencies. Your Excellencies, it is also pertinent to highlight para 15 of the same fact matrix that the Honorable Bench is referring to, Your Excellencies. However, he did precisely by distributing food grains to other parts of Jhanakland, Your Excellencies. But however, deaths from the Nanji region, predominantly from the Vajan community, resulted in the reduction of their population almost by half, Your Excellency. And this is pertinent to note also, Your Excellencies.
Please proceed.
And this act of Mr. Wolf shows his discriminatory policy against the Vajan population, Your Excellencies. Your Excellencies, furthermore, being a staunch Andalian as given in the factual matrix, the intention of Mr. Wolf was being loyal towards the Andalians and being discriminatory towards the Vajans in this instant case, Your Excellencies. In furtherance to what has been stated, the attack must be in consonance with the state policy, Your Excellencies. A policy which has a civilian population as the object of the attack being implemented by a state or organizational action, Your Excellencies. If the attack is directed, unless it is spontaneous or in isolation, then such act will satisfy the criteria. Your Excellencies, it is pertinent to note that such policies do not require a vast degree of organization or formality, Your Excellencies. It can be interpreted through the circumstantial evidence or the corroborative evidence in this case, Your Excellencies. Your Excellencies, the acts of Mr. Wolf by deliberately diverting the food supply from the Vajan population in the Nanji region, causing the famine to go from bad to worse and leading an event similar to that of the wiping out of the substantial population of the Vajan community, shows that his discriminatory acts were targeted against a particular civilian population in this instant case, Your Excellencies. Your Excellencies, the act against the Vajans in this case itself is proof enough for the existence of a plan with an objective to destroy the Vajan population, Your Excellencies. Your Excellencies, the suspect in this instant case further had the knowledge and the intent of the attack, Your Excellencies. It is not necessary for the systematic and widespread attack to consider the motives behind the act, Your Excellencies. The act may have been to personal motives or due to political motives, Your Excellencies, but the act must be directed towards the civilian population. And in this case, Mr. Wolf's intention was clear by taking actions in the course of time which results in the perpetration against the Vajan population and the subsequent devastation of the Vajan population that took place in the Nanji region of Jhanakland, Your Excellencies. Your Excellencies, furthermore, the acts of Mr. Wolf will be recognized as other and inhumane acts under Article 7(1)(k) of the Rome Statute, Your Excellencies. Your Excellencies, the elements of crime clarifying the reference to conditions of life may include the deliberate deprivation of resources for survival, such as food, medical services, or even humanitarian assistance, Your Excellencies. Other inhumane acts must possess a similar character to those crimes mentioned in under Article 7, Clause 1, Your Excellencies. The suspect created circumstances that caused substantial death by withholding necessities of life and other such essential resources that is required for survival, Your Excellencies. Other inhumane acts under Article 7 of the Rome Statute include food deprivation, policies of mass famine, and causation of physical or mental suffering of victims by denying humanitarian assistance, Your Excellencies. In this case, Your Excellencies, the waging population in the Nanjing region were deliberately denied access to resources for survival, including food supply. The actions of Mr. Wolf directing senior government officials to divert the food supply from the Nanjing region, specifically from the waging population, although the Andalian population also exists in the region, shows that his intent was discriminatory in nature and was a deliberate attempt of Mr. Wolf against the waging population, and which led to their subsequent destruction in this instant case, Your Excellencies. Your Excellencies, furthermore, Mr. Wolf intended to cause such injuries with the actions he committed by being complacent and being inadequate in taking necessary measures to the famine, to the ongoing famine that existed in Jharkhand, Your Excellencies. He deprived a certain set of people from food who did not belong to the majority religion or the Andal religion in this case, Your Excellencies. Being the head of the state, Mr. Wolf was aware of the conditions that existed in his state, but nonetheless, he actively was involved in the deliberate act against the waging population, and also he failed to take necessary measures, Your Excellencies, all of which amounts to a systematic and widespread attack. Subsequently,
Counsel.
Yes, sir.
Is the substance of your submission this, that incompetence can amount to genocide?
Your Excellency, incompetence may amount to a systematic and widespread attack in this instant case, Your Excellency. That is what is being contested.
If you're incompetent, then you're incompetent, then you can't do something. You failed in your, but would incompetence, unless you show deliberate incompetence or deliberate complicity of the state, you're alleging genocide. You're not alleging any other thing. You're alleging, like, really there has to be a strong pattern, there has to be a context. But here on one side, you're alleging incompetence, and the other side, you're alleging genocide. Do you think that's the substance of the question? Do you think that either the person is competent or incompetent?
Indeed, Your Excellencies, much obliged. Your Excellencies, in this case, during the course, through the course of my arguments, I established the deliberate nature of the intention, Your Excellencies. The deliberate nature is seen through the acts only by targeting the waging population, Your Excellencies. All the other minorities in this instant case, being Christians, were also not targeted. And being a staunch Andalian himself, he favored the Andalian in this case, Your Excellencies. Although it is pertinent to note that the Constitution holds the provision that it is a non-secular country, and it is and the Andalian population and their interests will be protected. But it is also pertinent to note that in the same constitution, it's given that he may not, or there may be no acts that are discriminatory to any other religion in the instant case, Your Excellencies. This shows that Your Excellencies, as the head of the state, Mr. Wolf had a legal obligation to take certain necessary measures, Your Excellencies. He failed to do so, and furthermore, he deliberately acted against a particular population, Your Excellencies. This by established the deliberate nature of his intent, Your Excellencies. Much obliged, Your Excellencies. But in conclusion, Your Excellencies, the subjective element, the objective element, and the contextual elements of the elements mentioned under Article 7 have been fulfilled, Your Excellencies, and hence it amounts to a systematic and widespread attack against the waging population, Your Excellencies. If I may take the course 30 seconds time to present the prayer before this honorable court, Your Excellencies. Your Excellency is.
And I don't know. I don't think there is any need for presenting
the prayer is on record, Your Excellency.
We know what the prayers are.
As rightly stated by my Excellencies, the prayer is on record, Your Excellency. It was an honor and a privilege arguing with this court.
You're welcome.
Thank you very much.
Greetings to the bench. The agent seeks permission to refer to the bench collectively as Your Excellencies. If it may please the court, this is the agent appearing on behalf of Mr. Wolf in the case of Prosecutor versus Tibmus Wolf of Janakland. If your excellencies are well versed with the facts of the case, the agent would like to proceed to the issues at hand. The issues at hand are firstly, whether the ICC is barred from exercising its jurisdiction over the situation in Janakland in the light of Article 17 of the Rome Statute. Secondly, whether Mr. Wolf had specific intent as required by Article 6 of the Rome Statute. Thirdly, whether Mr. Wolf's conduct can be considered to be a widespread and systematic attack against the Fijian population. The present agent would be dealing with the issue number 1. Subsequently, the co-agent would be coming in to deal with issue number 2, and then the agent would be dealing with issue number 3. The agent seeks permission to proceed to the arguments advanced. The first issue will be contended in a twofold manner. Firstly, there are certain exceptions under the Article 17 Clause 1 in which the ICC cannot admit a case depending on whether the case is being prosecuted or has been prosecuted by the concerned state, and whether the case has sufficient gravity or the accused has already been tried. Secondly, it will be contended on the grounds of state rights on admissibility. The agent seeks permission to move to the first argument. It is contended that Article 17 Clause 1A of the Rome Statute elucidates that a case is inadmissible if the state with jurisdiction is investigating the case in question, unless the state concerned is unwilling or unable to genuinely carry out the investigation. Furthermore, according to Article 17 Clause 1B, the case can also be held inadmissible if the case has already been investigated by the state and post-investigation the state has decided not to prosecute the person concerned. The ICC would not hold the required jurisdiction under Article 17 when either of these criteria are met. In this case, Your Excellencies, Government of Janakland, through a quasi-judicial committee independently set up, did initiate and completed a thorough inquiry over the alleged crimes against humanity with respect to the Fijian population. As mentioned in para 20 of the moot compromise, they came to a conclusion wherein Mr. Wolf was exonerated of all charges. Moreover, moving on to my second sub-argument, the doctrine of non-bis.
Ms. Counsel, what do you have to say about the principle of complementarity when it is quasi-judicial proceedings versus criminal prosecution? So how do you explain that?
Indeed, Your Excellency, the principle of complementarity shall be dealt in the further part of my argument. So if Your Excellency prefers me to explain it now or in the course.
I'll just put another question to you. You are saying the very fact that you instituted a quasi-judicial action and not a criminal an action from the criminal court, wouldn't it show that, of course, you were not genuinely interested in prosecuting?
Regarding the formation of the quasi-judicial committee, Your Excellency, the fact that the Office of Prosecution demanded for inquiry into the matter, and at the point wherein no other option was deemed feasible, rather except then actually setting up a committee that would specifically deal with the issue at hand in as fast as it could, the option of quasi-judicial committee seemed to be more fair and more tangible when an issue was raised regarding the head of the state.
So not a criminal prosecution.
So
obviously, you don't fulfill that test.
Regarding
in the present case, you could have instituted in complementarity. You could have instituted a criminal prosecution. You chose not to. That's a
indeed, Your Excellency, but we seek to clarify that when an investigation was demanded, then the method of investigation that was adopted was through was through setting up a committee specifically for this issue because of the gravity of the offence committed by the Prime Minister himself, and so that is why this committee was constituted specifically. The agent seeks the permission to move on to my second sub-argument.
Why quasi-judicial proceedings? Why not independent commission of inquiry? Why did you not initiate that?
At that point wherein it concerns to the head of the state regarding international crimes, setting up, as mentioned earlier, setting up of an independent committee regarding the investigation seemed to be more reasonable than a normal criminal proceeding that would be carried out for anyone else. For my second sub-argument, the doctrine of non bis in idem, which translates as not twice in the same thing, is a legal doctrine to the effect that no legal action can be instituted twice for the same cause of action. In the context of the ICC, non bis in idem can be seen as an aspect of general issue of complementarity of the jurisdiction. It is used to avoid repetitive trials for the same set of crimes. Since the complaint and statement of the prosecutor was discarded by the Quasi-Judicial Committee, it means that the national authorities have already exercised their jurisdiction and autonomy. The agent seeks permission to move to the second argument. It will be contended on the grounds of state rights on admissibility. The principle of complementarity recognizes that the states have a responsibility and a right to prosecute international crimes. The ICC exercises jurisdiction only wherein the national legal systems have failed to do so. It is established to safeguard a state's sovereignty. Moreover, the amount of resources and evidences a state has for a crime committed on their own land supersedes any international quorum. In this case, as well as mentioned in the para 20, a prior inquiry had already been completed with efficiency. Therefore, it can be concluded that the ICC is barred from exercising jurisdiction in this case. The agent seeks permission to invite the co-agent to take up the next issue.
Just one small question while on that, before your next counsel speaks. Can you say that the action that you have taken is a genuine action? Does it fulfill that test?
Regarding taking of the genuine action, as soon as the UN was asked to intervene and as soon as the prosecutor did frame the charges, all the resources were diverted into investigating the crimes as soon as possible, and Mr. Wolf did address the issue in a public domain. So just to make sure that the process happens efficiently, it does portray the genuineness of the state to carry out an investigation as soon as the charges were framed.
Counsel, do you have any citation whatsoever to show that something like this, some sort of a quasi-judicial action, would justify or help you to get around the jurisdiction of this court?
Regarding the citation of specifically
any authority, I mean, citation is I'm using it generally. Any authority, written authority, treatise, anything.
As of now, we've only relied on the Rome Statute and whether the much obliged, Excellency.
In fact, I was going through your memorial. Even in the statements, you have not dealt with this aspect.
Apologies, Your Excellency.
Okay, please proceed.
Greetings to the bench. The agent would be dealing with issue 2, whether Mr. Wolf had specific intent as required by Article 6 of the Rome Statute in a threefold manner. Firstly, the prerequisites of the crime of genocide are not met. Secondly, the perpetrator did not have the intent to destroy in whole or in part that national, ethnical, racial or religious group as such. Thirdly, the evidences which are provided by the prosecution are not authentic and lack in the probative value, thereby concluding that the genocide of Bajan population was not committed by Mr. Wolf with specific intent. Rather, it was just a calamity in a form of famine which created a dire situation for the people of Janakland. Now, the prerequisites of the crime of genocide are not met because firstly, his acts do not satisfy the definition of genocide as per Article 6C of the Rome Statute. And secondly, the contextual elements defined in the element of crime are also not satisfied. So the Article 6C...
And Ms. Counsel, sorry, just to interject. In paragraph 14, it is clearly mentioned that the number of deaths that have taken place is significant. So how do you explain the significant percentage of the Bajan population being the victims of this famine and not the majority?
Indeed, Your Excellency, to state that my third argument constitutes of how the media reports are not reliable, and for that specific issue we have the case of Cupresic, in which it is clearly stated that the media reports and newspaper reports are opinionated evidence and they don't provide a detailed history and detailed numeric data. So the Kuprick evidence clearly tells us that the newspaper reports lack in the authentic value, and they are much lesser in probative value too.
But it is corroborated in the facts of the case. It is corroborated by other evidence. So how do you explain that?
Coming to the corroborative evidence, which are the WhatsApp chats, as the counsel for the prosecution clearly stated that the WhatsApp chat shows the diversion of food grains, whereby the digital evidence or the WhatsApp chats were in the private domain. They were never, the transcripts were never made public, and they were in the private domain. Now here, the timestamp of the WhatsApp chats, its source or author, its recipient, and in fact, we still don't know whether the chats were manipulated or were sent from some other device which was not used by Mr. Wolf. So there we have clearly, target the authenticity of the WhatsApp chat, that they might have been tempered or manipulated in order to frame Mr. Wolf with such charges.
But counsel, don't you think, that we get, I think I understand what you're saying, but then don't you think we have to take it in the context of the election of Mr. Wolf as to what he got elected, what was his policies, and things of that sort. So can we see these things completely in isolation of each other? Maybe if you see them in isolation, possibly. But you have to see the context. In this sort of an instance, as you know, there are enough judgments that say that the context is important.
Indeed, Your Excellency.
What my learned brother is trying to say, the pattern. Please explain the pattern.
The pattern. That's absolutely. That's the
Indeed,
test.
Your Excellency. So if we come to the moot proposition in para 6 of the moot proposition, first line says, by 2002, Janakland began facing stagnation in its development and growth. And then in para 7, it is stated by 2012, the situation became a bit dire and several parts were facing food and water shortages. So that thereby, when Mr. Wolf had the agenda throughout his election campaigning that the country of Janakland is facing famine, and we can see that the famines were deep rooted in Janakland, and the famine was a natural calamity and not an intentional famine which was created by Mr. Wolf. And coming to the pattern, Mr. Wolf never through his words or speeches targeted any population. And for the commitment of genocide, an important element of crime is that the person should belong to a particular community, which is religious community in the particular case. So here he never targeted Vajin population through his words or speeches, whereby it shows that he did not possess the intent to hurt the Vajin group in the Nanji region. If Your Excellencies have no further questions, coming back to my argument that his actions do not satisfy the actus reus, which is mentioned in Article 6C of the Rome Statute, which says that perpetrator deliberately inflicts on the group conditions of life calculated to bring about its physical destruction in whole or in part. Now, the actus reus is divided into 3 parts: conduct, consequence, and circumstance. Here, Mr. Wolf had not deliberately inflicted conditions of life, as the government was taking all necessary measures to bring the situation under control, which shows the absence of the conduct of creating a situation of famine. And the government stated that they're going to put an embargo on all exports and redistribute the food grains, which clearly shows the active participation of the government to control the famine rather than omission on part of the government to bring the situations under control, rather than omission on part of the government. As for the consequence aspect, the group was not of any particular community. Rather, the famine which started from Nanji region of Janakland spread to the whole of Janakland, which caused death of not only Vajin population, but also of the total population of Janakland that was home to several other religions. It even lacks the element of circumstance, as it did not have a manifest pattern of similar conduct. Throughout his campaigning for the elections, he spoke the language of the population, which included 5 lakh people and not just the Andal religion. Never through his words targeted any religion for votes. Thus, his action lacks conduct, consequence, and circumstance, thereby establishing the absence of actus reus for the crime of genocide. Finally, if your excellencies have no questions, may I move on to the elements of crime? For the elements of crime, first element of crimes comes out, the conditions of life were not calculated to bring about physical destruction of the group in whole or in part. Besides the conditions being calculated to bring about the physical destruction, the condition must be inflicted deliberately. In the present case, there was not a deliberate attempt of Mr. Wolf to target any religion, but indicating that the crisis of famine has occurred. Rather, just like the past, Janakland was hit with yet another famine, which showed its early signs in 2002 and 2012. And Janakland began facing stagnation in its development and growth and shortage of food and water resources. It is clearly stated in para 6 and 7 of the moot proposition, as pointed out earlier too. Now, the famine was neither deliberate nor was it targeted. Though there were conditions, but the inflicted conditions were not deliberate on part of Mr. Wolf. Second element of crimes comes out.
The case of the prosecution is that the response was what is, they are targeting the response. They are not targeting what caused it.
Indeed, Your Excellency. For the response, Mr. Wolf definitely tried to control the situation, as he clearly stated that the situation is dire and this is the biggest challenge our population has ever faced. And I assure that everyone will prevail. This shows his willingness to control the situation. This shows that he is acknowledging that deaths have occurred. The country is hit by famine. It is a natural calamity. And even if he was incompetent to bring the situation under control in a period of time, that does not prove his intent, as incompetency cannot come under an international crime. Genocide needs to be proved with specific intent, while incompetency never proves the intent of the perpetrator. If Your Excellency is satisfied, I'll move on to my next argument, which is the person did not belong to particular national, ethnical, racial, or religious group. So the crime of genocide should target a specific group. So none of the group was targeted, as the death occurred shows that if by March 2020, 15,000 people of Nanji region died, 3,000 belong to other religion. And if by June 2020, 60,000 people died, 10,000 belong to other religion. And also, 5,000 from other parts of Janakland, people have died due to this dire situation and famine that was prevailing in the whole of Janakland. Thirdly, as stated earlier, there was no manifest pattern of similar conduct. If Your Excellencies are satisfied, may I move on to the next argument? The next argument is about the specific intent, which is Mr. Wolf did not have the intent to destroy in whole or in part that national, ethnical, racial, or religious group as such. Genocide involves two subjective elements. General subjective element, which consists of intent and knowledge, as defined in Article 30 of this Rome Statute, and a specific intention or dolus specialis to destroy the targeted group in whole or in part as such. So Mr. Wolf did not possess the general intent, even though Mr. Wolf possessed knowledge of the deadly conditions in Nanji region and the increasing mortality rate. He did not possess the intent to target any particular group, as he tried to control the situation. As a matter of fact, if a region that has suffered more will eventually take a longer period to recover and get back to the original situation. It has exactly happened with Nanji region. It cannot be termed as intent of deliberately inflicting a situation of famine. It was famine for the whole of Janakland, which like the past affected all regions and religions. Now, in the case of prosecutor versus Dragon Joke, The trial chamber has clearly stated that the knowledge of inevitable or likely destructive consequences was not sufficient for the conviction of the defendant. Also, coming to the next point, which is about the specific intent. Now, specific intent is always in the mind of the perpetrator, and it cannot be calculated directly looking at the perpetrator actions. So it always comes with circumstantial evidence. To prove the circumstantial evidence, here in the present case, Mr. Wolf does not possess specific intent or dolor specialist, as from the moment in March 2020, when he came to know about the deaths of 15,000 people in the Nanji region, he acknowledged the deaths, took it seriously, and started taking all necessary measures to bring the situation under control. Now, this act of Mr. Wolf of acknowledging and taking steps to improve the situation and stop it from spreading to other parts of Janakland shows that he had grief for the people who lost their lives, rather having an intent to destroy their lives. Now, the problem of famine, as stated earlier, it is a deep-rooted one, and the people who immigrated to Janakland were from Rainbow Land, which had a Vajan population as majority, and it was hit by famine earlier too. And again, the same situation came up for this government. It does prove that it was neither inflicted nor intended. Not only the Nanji region, that is the Vajan population, has lost their life to this calamity, but also various other religions were succumbed to death. And if we calculate the number of deaths of the people from other population, that counts to 18,000, which in itself is also a substantial part, because losing 18,000 lives does not constitute that a small number. There was deaths of other from other religions and regions.
Counsel, do you have anything to any citation or any passage from a treatise to substantiate what you are arguing right now?
Indeed, Your Excellency, citation for regarding which statement, if I may know that for.
No, you substantiate your argument on the genocide aspect of it.
Indeed, Your Excellency, just give me a minute, I'll get back to you with that. Apologies, Your Excellency. So for this case, now genocide is a case which depends on case-to-case basis, and it depends on the circumstantial evidence. So there are no relevant or similar facts of a case which can determine that in the same way genocide has occurred in other cases.
No, something to show a case law that demonstrates that in order to prove genocide, there has to be enough circumstantial evidence to substantiate that in your defense.
Indeed, Your Excellency, for the circumstantial evidence, I'd just like a minute. It is a ICTR judgment of it is the judgment of Umar al-Bashir, prosecutor versus Umar al-Bashir, where it was stated that the circumstantial evidence plays a major role. And also it has been mentioned in my memorial one ICTR judgment, which I'll quote the paragraph for your convenience.
I've seen that.
So if
Bashir is the Sudan, is it?
Indeed, Your Excellency.
Okay.
Moving on to the fourth argument, which was stated earlier too, that the evidences that are provided by the prosecution lacks in authenticity and probative value. The newspaper articles are generally not considered as reliable sources of evidence and often excluded for lack of probative value. The newspaper articles provide the opinionated evidence and rarely provide detailed information about the events. Also, the reports are not corroborated with other material, thus there are not sufficient evidence. And all the numeric data and images of the warehouses flowing with food grains was just reported by the media and news. And also, in the present case, the Office of the Prosecutor has not provided any witnesses or oral testimonies to prove that the media reports are have the authenticity and the probative value. And for the digital evidence, the source, author, the timestamp when it was sent, and its recipient is an important aspect to look for the WhatsApp chats, since they were not in the public domain and in the private domain, and the transcripts were not published. So it forms a major argument that WhatsApp chats can be easily manipulated. Also, the chambers have proved that the burden of proof of the reliability of a document or evidences lies on the party seeking its admission, which the prosecution has failed in this particular case, as they are proving the WhatsApp chats for the diversion of food grains as their primary evidence. Now, concluding with that, these evidences of news reports and WhatsApp chats, authenticity, reliability, and probative value, thereby concluding that Mr. Wolf did not possess the specific intent as per Article 6 of the Rome Statute, and he did not, his actions did not satisfy the definition of genocide and the contextual elements of crime. Much obliged, Your Excellencies. If you don't have any further questions, I would like my co-agent to come up and take up on issue 3. It was an honor pleading before you.
The agent seeks permission to move to the third issue at hand. The third issue will be contended in a twofold manner. Firstly, Mr. Wolf's conduct does not fulfill the requisite essentials of a crime against humanity as illustrated by the Kipresik judgment. Secondly, the prosecution failed to meet the evidentiary burden to establish that the defendant facilitated the commission of a crime. The agent seeks permission to proceed to the first argument. It will be illustrated in a fourfold manner. The agent seeks permission to share the relevant authority. Moving on, firstly, the nature of the act was not widespread or systematic. The term widespread can be interpreted as a large-scaled, frequent set of actions affecting a large part of a population. The term systematic can be defined as an organized course of conduct as a result of a prior strategy involving public or private resources. In this case, death of 60,000 people of one nation throughout an elongated period of time due to natural events cannot be construed as a large-scale organizational crime against a specific population. Secondly, the attack was not directed at a civilian population as illustrated by the Tadic judgment. The term attack insinuates mistreatment or multiple commission of hostilities against a civilian populace. Multiple hostilities were never conducted.
Ms. That is the exact argument for the prosecution, that this was targeted against civilians.
Regarding that, Your Excellency, we are making a counter argument that it wasn't targeted against a specific civilian population, and the commitment of multiple hostilities never occurred. There was no organizational crime that was perpetrated by the state of Jhanakland or Mr. Timbus Wolf, for that matter. The affected victims were the generic citizens of Jhanakland. The fact that a civilian population has to be the prime and objective target of the attack. In this case,
but can one instance also amount to it or not?
One instance can also amount to it, but the magnanimity of that instance has to be very high. And in this case, no concrete grounds or proofs have been defined by the prosecutor, establishing the fact whether there were multiple hostilities or one instance that was so magnanimous that led to a crime against humanity being perpetrated. If Your Excellency allows, the agent would move forward with
Counsel, I don't want to interfere in your English. I think that's not very important. But magnanimous and magnitude are two different things. I think what you want to indicate is magnitude.
Yeah, apologies, Your Excellency.
Very different. But be that as it may, please continue.
Much obliged, Your Excellency. I'll take care of that. Moving on, so in this case, no concrete grounds have been provided, and the fact that the prosecutor was not able to establish that a series of organizational acts were committed in order to persecute Vijans specifically. Famine is a natural disaster affected the whole country from a larger perspective. Thirdly, the attack was not in furtherance of a state policy. For that, the agent seeks permission to share the prosecutor versus Mudu Kumra judgment. A large-scale attack can be considered as a crime against humanity if it is qualitatively motivated by a state policy. Therefore, an attack this big can only be executed if it had gained the state's support. In this case, the alleged acts of Mr. Wolf do not have substantial evidence and official reports backing up the claims. Moreover, no course of actions or policy structures were devised or directed.
Ms. Counsel, there cannot be any official statement on it, obviously, because your official statement says that everything is hunky-dory. So how do you, I mean, there is no evidence to show, you will say that there is no evidence to show otherwise, but then the entire set of facts and the way the situation has been handled clearly shows that there has been lapse on the part of Prime Minister Wolf.
Indeed, Excellency, but we seek to clarify that when it was accepted that the country was affected with famines, Mr. Wolf did take tangible and effective measures, let it be putting an embargo on all the exports as referred in the para 14 of the compromise, or acquiring the food grains and then distributing them in order to reduce the famine. So the fact that policy structures, apologies, the fact that policy structures were devised to reduce the effect of famine and which showed results, and the famine in most of the areas of Janakland was controlled, shows that there was no policy made to persecute Vijayans specifically. Rather than that, in the opposite of it, policy structures were directed so that the situation was dealt with efficiency.
But the reports suggest to the contrary, Ms. Counsel.
Apologies, Your Excellency.
No, the reports on the number of deaths which have taken place, the disproportionate number of deaths which has taken place, that shows to the contrary. That is evidence to the contrary.
Regarding that, Your Excellency, the fact that even if the deaths escalated in a matter of 2-3 months, allegedly the deaths escalated in a matter of 2-3 months in specific areas that were affected from a long time, in general, the whole country did recover from the famine. That proves that the policy structure was effective in controlling the famine. One region which was affected from the starting of the famine, it is a fact that one region that has been affected takes more time to heal. So if we look at it from a larger perspective regarding how Mr. Timbers Wolf dealt with the situation, the policies and the organizational changes that came about resulted in the reduction of the effect that was caused due to the famine. Janakland, being a democratic country, it treated all parts equally with the maximum effort to reduce the loss of life. The agent seeks permission to move on to the fourth sub-argument. Fourthly, the act was not committed with the requisite knowledge or intention, as this essential can be found in the prosecutor versus Cupresi judgment. To convict someone of crimes against humanity, it must be proven that there was an intent to commit the offense, while also knowing that there is an attack on the civilian population. The prosecution has failed to establish with sufficient evidence that there are substantial grounds to believe that the perpetrators acted with an intent required by Article 7, Clause 1.
Counsel, what about the WhatsApp chats?
Regarding the WhatsApp,
there's one thing, of course, you've attacked it on admissibility and admissibility of evidence, etc., etc. We know that. But do you think if we take the WhatsApp chats for what they are worth, don't you think it shows that? It shows a clear intent.
Indeed, Your Excellency, but if we assume the admissibility of WhatsApp chats, then we are assuming that Mr. Wolf had the intent, and we are assuming that the subordinates were directed. So even if we proceed with that, then it wouldn't be ideal or it wouldn't be acceptable, because after admitting that there is no defense that could be created which would protect Mr. Timbers Wolf, the only way to counter that and the only way to deal with that is to prove that the WhatsApp chats, even if you forget about WhatsApp chats, the only information that is given is just one line that explains the WhatsApp chats. The transcripts of them are not available. What exactly the orders were given, that's not available. To which subordinate government officer it was given is not available. So even if we talk about WhatsApp chats, they are very arbitrary and vague in this case. So to accuse Mr. Wolf of such grave crimes, these WhatsApp chats shouldn't be assumed to be acceptable at the first place, Your Excellency. Coming back to my argument, the death of Vijayans or other victims as whole occurred due to a shortage of food and famine, and a famine happens due to multiple geological factors, and orchestrating an attack revolving around this event is too bleak a possibility. Therefore, intent cannot be conclusively established. The agent seeks permission to proceed to the second argument.
I have one last question for you. In para 22, your Prime Minister has made a statement that I will ensure that my lawyers are present before the Honorable Court to guide it through the relevant authorities in this regard and help correct its mistake. So do you think this is a acceptance of the jurisdiction of the tribunal?
Indeed, Your Excellency, it is, if we read the whole paragraph, the fact that the charges claimed by the prosecutor was clearly denied, and it was ensured that the matter will be investigated. And even after, if the matter was after the investigation proved to be right, and if the charges were framed against them, then the lawyers would have been able to counter it in the Honorable Court. So the precondition was that after trying substantial evidences would have proved that Mr. Wolf would be held under Article 6 and Article 7 of the Rome Statute, but that did not happen because the committee discarded the allegations. The agency seeks permission to proceed to the second argument. It is contended that the prosecution failed to meet the evidentiary burden to establish that the defendant facilitated the commission of a crime. To establish individual criminal liability for ordering a crime, the order must be made with the knowledge of consequence that follows after carrying out the order. The orders given by the defendant with the intent of ensuring food supply to areas and executing efficient measures that were being taken to minimize the casualties do not prove that he was aware of a substantial likelihood that crimes might be committed in the execution of this order. Media reports and WhatsApp chats are not tangible and definite set of proofs that convey that such wrongful orders were passed. Therefore, it can be concluded that Mr. Wolf's conduct cannot be considered to be a widespread and systematic attack against the Fijian population. If Your Excellencies have no further question, the agent would like to move to the prayer. Wherefore, in the light...
No need for the prayer. Thank you.
Much obliged, Your Excellencies. The agents rest their case. It was a pleasure arguing in front of this Honorable Court.
Thank you very much.
Agent seeks permission for rebuttal, Your Excellencies. Much obliged, Your Excellencies. The first point is that the, as stated by Speaker 1 initially, that is the admission of assumption of diversion of resources cannot be assumed, Your Excellencies, since it is the outside of the fact matrix, Your Excellencies. Moving ahead to the next point, in para 10, despite the presence of dire conditions, Your Excellencies, it was his popularity, though the famine existed since a long time, we can see that because of his affiliation towards the Andalian community, because of his popularity in the subsequent election, he won. Mr. Wolf won the election, Your Excellencies. People did not consider other situations, Your Excellencies. Your Excellencies, it is pertinent to note that Wolf, in his individual capacity, coupled with being the leader of the country, was in full capacity to take control of the operators in this, the way things function in the state of Janakland. Despite the media reports and news of extreme shortage of water in the region, Mr. Wolf and his government did not take cognizance of the same, and the same was denied, Your Excellencies, and thus the same thing can be seen in para 13. He just acknowledged the situation, but no action was taken, Your Excellencies. Subsequently, in para 14, Your Excellencies, when this particular aspect spread to the complete region, complete state of Janakland, Your Excellencies, it can be seen that Mr. Wolf took some action. This clearly shows that especially Nanji region was completely ignored by the government, and the execution of Mr. Wolf's actions were targeting the region community. Your Excellencies, what has to be taken into consideration more importantly is what was stated by Mr. Wolf's office in para 15. Mr. Wolf's office released a press release which stated the following, where they admitted that the situation in Nanji region is still dire despite him taking actions in the above paragraph, where he says he will redistribute food grains by placing an embargo. So though they state that though Mr. Wolf states that he has taken this action, we can see that the Nanji region is still under dire conditions, which clearly shows that there is a discriminatory approach towards the regions residing in the Nanji region, Your Excellencies. Your Excellencies, it is also pertinent to note that if Mr. Wolf did not have the intention to single out only the regions, Your Excellencies, why is the ratio of deaths not in consonance with the ratio of the population of people living in the Nanji region, Your Excellencies? Furthermore, Your Excellencies, it was stated that the Nanjis, that the regions do not constitute a religious, ethnic, or any other group which is mentioned under Article 6 of the Rome Statute, Your Excellencies, and the prosecution would like to state that that is incorrect. It is clearly mentioned in the proposition that the region is a religion that is practiced in the state of Jharkhand, Your Excellencies. Subsequently, Your Excellencies, the admissibility of evidence was questioned, and it was stated that the examination of witnesses were not conducted. Thereby things cannot be taken into consideration. Your Excellencies, it is pertinent to note that we are before the pre-trial chambers and not before the trial chambers, Your Excellencies. It is pertinent to note that here we are just the pre-trial chambers will just decide if charges have to be framed against the suspect or not framed against the suspect, and evaluation of witnesses, examination of evidences, and all these aspects will be taken in great detail in the trial stage, Your Excellencies. That subsequently, Your Excellencies, it was stated that a policy structure was in place. It is pertinent to note that this policy structure that was in place was aimed at reducing the famine, Your Excellencies. Which was aimed at reducing the famine was done in a selective manner that was focusing only the Vegan religion, Your Excellencies. It was done in a selective manner, Your Excellencies. Your Excellencies, it is also pertinent to note that the prosecutor stated that even one act is sufficient if the magnitude is substantial. And the prosecution is reiterating the same point that although 22% is not a majority, a significant amount of death has occurred, whereby the aspect must be taken into consideration. And the prosecution also reiterates that WhatsApp is considered as secondary evidence, no doubt, but the subsequent acts, the action that can be seen, the subsequent acts leading to the destruction is considered as direct evidence. Thereby, both of it together must be considered, Your Excellencies.
To answer the questions of my opposing learned agent, all the arguments have already been stating about the intent, about how we provided the people with food, how Mr. Wolf, but also still she stated that Mr. Wolf was a devout Andalian as stated in the proposition. Now the meaning of the word devout is that he is loyal to his religion. That nowhere mentions that he'll target other religion and wish for their death or intent their death. Also, she stated that Mr. Wolf had a popularity and thereby he won the elections. The popularity in itself is able to comprise that even the Vegan population was with Mr. Wolf and hold hand with him to make him the Prime Minister of the country and had faith in it. Now, when someone receives the popularity and the faith of the people, he won't let them down. Rather, he'll help the country to get over it. Also, it was a calamity, not a famine. It has been clearly stated, and also a famine which was not intentional. Now, my opposing learned agent also stated that he did not take the cognizance. To prove that point, we'll come to the same paragraph she pointed out, para 13, last 5th line, where it is stated, the government is taking all necessary measures to bring the situation under control, and it is important to appreciate the problem is a deep-rooted one. As soon as he get to know about the deaths, he took the cognizance of the problem and started taking measures to make the situation better and stop it spreading from to other parts of the Jharkhand. Also, it was stated that Nanji was still the worst affected region and was in dire situations. Through the WhatsApp chats, as it states that the food grains were directed to other regions. In the whole proposition, except the assumption made by the prosecutor through the WhatsApp chat, is nowhere mentioned that Nanji region did not receive the food grains. what is mentioned in the proposition is that Nanji was still in the dire conditions. So the two statements are very different from each other. If the Nanji region people gets a limited amount of food grains, but this situation is not as good as other parts of Janakland, then obviously need more food grains and more water to get back to the situation where other parts of Janakland were. Also, she stated that significant amounts of deaths have occurred. That's what the Mr. Wolf, that's what we as agents from the side of Mr. Wolf are stated. Significant amount from all religions and regions, significant amount of deaths from all religions and regions have occurred. And that's about the famine and the calamity, not something with intention that is targeted Vajan population. And to prove such international crimes, an intent to target a population is a very important aspect where it is missing because people from all religions and regions have died. Much obliged, Your Excellencies. If Your Excellency does not have further questions regarding to the rebuttal I made, I would like to move on to the SAR rebuttal. For the SAR rebuttal, the prosecution keep on stating the case of prosecutor versus Katanga. Now, to point out to Your Excellencies, the facts of the Katanga clearly stated that people were attacked with machetes, spears, arrows, and heavy weapons, and they were murdered through it. In this particular case, there's no weapon as such used for killing the people or murdering them.
I would like to interject 1 minute. I'm sorry. I would like to
let me
court officer with regard to the format of the competition. That's my only contention, Your Excellencies.
That will leave to the organizers, if the organizers can come and solve this issue.
Indeed, Your Excellency, so I'm asking the organizers if I could speak to them.
Your judges, if you all accept the arguments from the both end, after the defendants have made the SIR rebuttal, if you allow them to speak again, then the organizers have no issues. But if the bench does not allow with it, then we cannot help the same. The decision is solely of the benches. The organizing committee doesn't have a say in it.
I would also like to state that the format of the competition just stated there will be a rebuttal and a SIR rebuttal where the defense is just going to answer the questions, but however, the defense can't make statements again and the prosecution answering. So I'm just a little.
Okay, then we'll take the answering questions and SIR rebuttal together. So your time limit to that extent we limit. So obviously the answering questions will be part of your SIR rebuttal, so I will limit that. And then please continue and then wrap up fast. Because
indeed, Your Excellency.
In that case, the time is also over, Your Excellency. Just to point it out, thank you. Much obliged, Your Excellency.
Indeed, Your Excellency. So the SIR rebuttal, to point out this from the side of prosecution, the SIR rebuttal first contains the answer of the rebuttal, and SIR rebuttal is something different. So
irrespective of anything, I'm not going into the technicalities.
I just had one more.
I think you have a.
Please finish your arguments both sides. I think you say whatever you want, but in a precise, concise manner.
Yes.
Indeed, Your Excellency, just 30 seconds more. So the prosecution was stating the case of Katanga continuously, and as stated, there was mention of machetes, spears, and that how the deaths occurred. Secondly, they stated the case of Bemba, which for proving the evidence of media reports and WhatsApp chats. Now, Bemba case, there were transcripts from testimony of 77 witnesses, 704 items of documentary evidence, and 40 witnesses of oral testimony. So they had the testimonies orally and both documentary, which gives a very huge number. Rather, in this particular case, we only have one WhatsApp chats and media reports, which are not as reliable as they are. They may be an approximate figure. That's all, Your Excellency. Much obliged.
Thank you. So we are treating your SIR rebuttal and you're answering questions together. Okay, thank you. Okay.
Judges, we would now request you to give a feedback to the participants.
Okay, then I think should Chinmay go first and then I'll follow. But I think he's muted. Chinmay, you're muted. You're muted.
Chinmay, sir, you're on mute. If you can hear us, you're on mute. Please unmute yourself. Thank you.
I said that both parties argued very well, and I've learned a lot from you.
Yeah.
It was a pleasure judging you. But the only suggestion that I want to give to all of you is that when the judges are asking questions, you have to understand the questions, answer the question, and then move ahead. Because sometimes the judges are asking you questions that they are trick questions. So you have to know that you are being assessed on those questions. I think the anxiety is to answer the question. Of course, the anxiety is always there, but you need to take a step back and then think and then answer. Because the judges are not expecting an immediate response. They're expecting a considered, thought-through response. So you take a step back.
Shashiji has something to say, then
very good argument, and of course it was good to be with all these students participating in this mute court competition. And yes, while replying the query, they were not understanding the question raised, and therefore they were deviating and coming to the same point from where the question was put. Anyway, it's a process, learning all the time. We hope and I wish all the best to the participants. Thank you all.
Pradeep sir, will you say something?
Yes, it was really nice to hear both the groups, and both of them actually were prepared very well. I would not say that sometimes we all face this kind of problem. It's not that you only, the questions raised by Mr. Sen, Vikramjit Senji and Chinmay, it was a very seasoned question. So I don't say that even if you lack in answering somewhere is not a demerit, or you all are very good. And this effort is really commendable. The kind of effort you all made, that is really commendable. And I think Chinmay has appeared in international court with Ghulam Banawati in 2-3 matters. So he has that kind of experience. And Mr. Sen has also witnessed that. So you all are doing well. And this subject was not a very easy subject. Genocide, normally hardly around 97 cases are there with ICC. And most of them, I think they were discharged, and some of them were prosecuted. They have their own prison, but there are so many other complexities in those. So really, you all did very well, and I'm really happy to see that you performed exceptionally well. I will actually acknowledge your hard work. Thank you.
Okay, I'll just say, I was just tallying the marks. I think very, very close. I'm not entitled to disclose the marks. I think extremely close, and both sides were extremely well prepared. And I don't think I mooted when I was in the law school, but wasn't as close to the amount of preparation which you people had. The knowledge of everything of the subject was very, very good. And most of the times, the answers, of course, you may have taken time to come to the answers, but the answers were absolutely bang on and correct. That's my perception. The other question which Chinmay sir flagged is a question which broadly as to the style or the approach towards mooting. Mooting is, according to me, where you are being judged and marked separately. So you have to keep that. It is like advocacy in some ways, and it's not like advocacy in some ways. In advocacy is you want the relief. In mooting, you are being judged for your performance. So your performance has to be holistically good. And in that case, we had to prod you to answers. That I don't think should have actually happened. But that's, as Shashiji said, that's a process. You're all going to grow up to it. And I'm sure you're going to be, I'm sure I see all of you much better advocates than I am. So all the very, very, very best.
It's a great appreciation, Vikramjit ji.
Thank you.
And it's also great to see all women from both sides. So this is one thing which I really enjoyed. Very happy.
In fact, I thought that it showed the absolute changing times.
Yes,
because
absolutely.
I remember my mooting days when we were largely men. Of course, there were some very, very competent women, but to show, now to see women on both sides at this level, it shows, things are changing. As what do they say in our Hindi? Desh badal raha hai. So that's good.
Thank you so much. Thank you.
Thank you.
With this, we come to an end of round 1 of the finals. I would like to thank our judges for their valuable time and feedback that I'm sure our participants have taken in good spirit. I would like to thank the participants for giving their very best and making this competition an interesting and challenging one. Before we leave, I would request all the judges and the participants for a picture. Atharva, please tell us when you're ready.
Yeah, I'll count to 3.